Hello and welcome. I am Tom Axworthy, Public Policy Chair at Massey College, and this is the second in our webinar series on ethics and ethical issues in our current times. Before I begin to introduce our panel and the issues that we'll be addressing today, I wish to acknowledge this land on which Massey College operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississauga of the Credit River. Today, this meeting takes place and still the home to many Indigenous peoples from across Turtle Island, and we are grateful to have the opportunity to work on this land. So, ladies and gentlemen, the ethical series at Massey began last month with a discussion of political ethics. Today, we are raising the major issue of ethics in international relations. To help us, we have a very distinguished panel, Lorraine Weinrib, who is school, and were it not for COVID, just about this time, Lorraine and I had talked about having a major conference at the University of Toronto on the Charter and its application to human rights. Next, we have the Honorable David Collinette, a former Minister of Defense and Transport, and the chair of the NATO Association of Canada. So a man who in his own decision-making life in public has had to wrestle with a variety of ethical issues. And Tina Park, who is a lecturer at Trinity College, is the chair of the Canadian Responsibility to Protect Center, and is a very noted asset to the Interaction Council as one of our experts on international relations. So I'm delighted that such talent has joined us to talk about ethics and international relations. So I'll turn first to Lorraine, where, of course, we have philosophically on human rights and on its relation to international relations, really right from the start, almost the first or second history ever written. Thucydides says that, in his view, international relations is about the powerful doing what they can and the weak suffering what they must. So realpolitik has been part of international relations, perhaps the dominant strain, right from the start. But at the same time, gradually, slowly, concepts of human rights and the value of individuals and the fact that humans should never be the means, but should be the end, that has grown and has contended with the forces of realpolitik. So I'd like to turn to you to start us in discussing the concepts of rights internationally and domestically, and perhaps how the international debate that we are having today might even have an impact on things like our charter and domestic concerns.
Thank you, Tom. Thank you for inviting me. And I do hope we'll eventually get to the state where we can do our charter conference.
Right.
It's a pleasure to be here. And the first point I want to make as a law professor is that, well, I can't think of a better term to describe international law than international law. It's not law in the way we usually understand law. It's obligatory in some of its presentations, but the enforcement mechanisms are in fact very weak. And so international law in regard to ethics and human rights is aspirational to a great extent, but it has had enormous influence all around the world. It has transformed the most basic structures of our understanding of governance and of the power of the state, as Tom alluded to, and also it has created a network of states that have committed themselves to exercise their power in relation to their populations, but also in relation to each other and in relation to refugees and stateless people, in ways that are inspired by the highest aspirations of ethical behavior. Now, in any discussion of international human rights, it's important to remember that the ideas were present. The ideas come from Enlightenment philosophy and even earlier theoretical work, but the concepts were engaged as an international and national project of conformity in the aftermath of the Second World War, where there was the breakdown of moderate liberal democracy in the fall of the Weimar Republic, which unleashed terrorism and the worst atrocities that mankind is capable of. The core concept is, as Tom alluded to, the idea that each individual is an end and not a means. And that's to some extent a very cryptic statement, but what I prefer to use as the encapsulation of the core idea, which includes the idea and expresses the idea that each person is an end and not a means, is that each person possesses equal and inherent human dignity. Now, there's a lot of literature on the idea that the concept of human dignity is empty, but it's not empty because it is filled with the aversion to, the negation of the older ideas of power, and also not only the power of the state, but the power of any kind of social hierarchy based on birth, wealth, nationality, family, identity group, sexual orientation, gender, physical ability or disability, illness, et cetera, et cetera. All of those personal characteristics at one time or another were characteristics that states use to disadvantage people and to render them unable to carry on any kind of decent life. The idea of equal and inherent human dignity is expressed in many documents that are called declarations, and so they're not legal documents. We like to think of the Declaration of the Rights of Man, 1789, the Declaration of the Independence of the United States, 1776, as leading up to and infusing the Declaration of the United Nations Declaration of Human Rights of 1948, which itself infused and generated a very, very intensive development of new constitutions in post-colonial states and renovation of constitutions in states that had complete or partial constitutions and infused new interpretation of old constitutions. And this is how Canada comes in, because our story is very distinctive. We had a constitutional structure that was set up under colonial arrangements, and there was really never any serious effort to give us a comprehensive constitution. And what this international human rights commitment to equal and inherent human dignity did right after the Second World War was produce enormously effective public interest group pressure for Canada's adherence to the International Human Rights Declaration and then the covenants, which Canada volunteered to oblige itself to follow. and also led to the failure of Canadian law to use its existing components to protect equal and inherent human dignity. It led to the long, bitter battle that produced our Charter of Rights. Now, one of the things that's very important to understand is when you have a Bill of Rights that is infused with a concept rather than tied to a concrete text produced in a concrete moment in time, as the American Constitution is conceptualized, you have a living constitution. You have a constitution that can absorb the growing number of declarations and treaties and covenants that the international human rights system produces. And you also have, because you have this vertical influx of ideas from international documents and instruments and adjudication coming into these national constitutions that are living instruments and desire to understand how these concepts can be actualized over time in different situations. You have also the possibility of vertical integration where, for example, Canada looks to other international instruments that have no relationship to Canada formally, like the European Convention on Human Rights, and other regional instruments when we are not in that region. But you also have constitutional conversations and borrowing and export between states that have similar constitutions. So we have in Canada all sorts of Supreme Court cases that look directly at international law, human rights jurisprudence, and text in order to elaborate the meaning of the constitutional rights and freedoms that the Charter protects. But we also have an amazing flourishing of comparative constitutional law. And there are very interesting patterns of what is borrowed. But one of the things I find most interesting is the borrowing, not just of the concepts and the legal framework that protects the concepts, but also the methodologies of how the courts of constitutional and human rights jurisdiction adjudicate rights protection. And this is where Canada has had an enormous contribution to the world, methodologies, but also where Canada has looked far afield in this horizontal comparative engagement to countries like Germany and Israel and South Africa, countries not connected to us in any formal constitutional way, to not only look at what they're doing, not only to follow their path in absorbing these international human rights norms, but also to examine how they have and demonstrated how we can fine-tune these methodologies and learn from them as they have learned from us. So this is an enormously fruitful and flourishing engagement in the project of human rights protection. And it is something that the Supreme Court of Canada has really excelled at. We're experiencing now a little bit of a pushback against the strong normativity of some of the original readings, but so far there have been waves of this kind of pushback in the past, and the Supreme Court has experienced the phenomenon in a resilient way and returned to its original strong commitment to the human rights project and equal and inherent human dignity. So even though when I was educated as a lawyer and when I practiced as a constitutional lawyer for a decade and a half, I had no need to resort to any international or comparative material. In fact, I experienced in the Supreme Court of Canada situations where other lawyers representing governments, I represented the province of Ontario, where other lawyers for other governments would put forward comparative or international ideas or methodologies or whatever, and the Supreme Court would just cut the argument down, cut the lawyer down, say this is not appropriate. But now, if one is a constitutional lawyer, one simply can't work without a deep understanding and familiarity and ability to work with the concepts and the legal framework in the international human rights system. So I would be happy to develop any more detail about this, but just let me say that hundreds and hundreds of Supreme Court of Canada cases have been decided on the basis of international and comparative human rights material.
Good. Well, thank you. Thank you very much. David, we've just heard from Lorraine about the growth of the values behind international law and how international law may also now affect our own Supreme Court and so on. But we've also had philosophers of realpolitik like Machiavelli say that no statesman should be held account to the normal moral virtues, that statecraft is ahead of moral craft. And in the field of applied ethics, I know there'll be great interest in your experience as a minister of the Crown on some of the ethical dimensions of key decisions that you had to contribute to. Would you give us some of those experiences, please?
Well, thanks very much, Tom, for asking me today. And given the current global context, I think the topic is very much a good one. Certainly, my experience of my time in Parliament tells me the answer is yes to the question: ethics in international relations, do they exist? Just as most people have an explicit or implicit standard of moral, or call it an inner compass, a morality or inner compass, that subjectively determines what actions are right and those that are wrong. Every society has moral principles that guide the behavior or conduct of its institutions and its citizens. Moral principles and ethical behavior have evolved over the centuries and have become codified in laws, rules, regulations, and cultural practice. And we've just heard some of that from Lorraine. With its mores and laws, a society clearly defines what is required, allowed, or forbidden of its citizens. The question of ethics in international relations reminds me of two well-known proverbs or expressions. The first, all's fair in love and war, which allows for deceit, illegality, among other things, in the pursuit of a goal. Perhaps that's what you were thinking of when you cited Machiavelli. And then survival of the fittest, which of course is a precept of Charles Darwin's evolutionary theory, and a term appropriated by 19th century capitalists to justify laissez-faire economics, war, and racism. Astoundingly, we have just lived through 4 years of the application of these unfortunate proverbs under one American president, where the rule of law, morality, truth, and ethics in domestic as well as international affairs have been sidelined in the promotion of self-interest. Now, obviously, defense policy is an instrument of foreign policy, and if foreign policy should be ethical, then it follows that defense policy must be ethical as well. Military ethics judges and justifies the morality of military actions. It defines the norms of good behavior for individual military personnel and develops standards. However, there's one key issue about military behavior that attracts the focus of observers: when and how to use physical force and to what limit. The men and women of the Canadian Armed Forces, all volunteers, have for over a century sustained injury and given their lives to protect us and Canadian democracy. It's accepted then that members of the military will inevitably have to fight, injure, and take the lives of our adversaries. Such is the brutality of war. The armed forces are the instrument of the state, and the state's orders must be obeyed. To be a member of the military demands uncritical loyalty and obedience to the chain of command, and atop that chain of command are the elected representatives of the people. Yet World War II and subsequent war crimes trials questioned unbridled obedience to one's superiors, that there are illegal state laws in the eyes of the international law. Do military personnel have a duty only to the nation or to a larger ideal? That is what is right, what is moral conduct, what is just, what is ethical. In short, does the end justify the means? And of course, to address these crucial issues, the international community over the past century has created an ethical framework, which is the rules of war, the Geneva Conventions, to ensure that certain acceptable behavior, even in horrible circumstances, is carried out. And I just want to give a few examples, Tom, in the time that I have, of things that I addressed as a minister of defense, and also another one where I was at the cabinet table, which was a significant decision, the last significant decision of the Liberal government under Jean Chrétien. You know, deployment of the Canadian soldiers to the United Nations mission in the former Yugoslavia exposed our troops not only to traditional peacekeeping mission, but also to an internecine war. The rules of engagement that were established by the UN for conventional peacekeeping turned out to be totally inadequate for the environment where atrocities and war crimes were taking place. And so in Canada's, Canada had to ask the question, should we negotiate or use force when Canadians were being held hostage, as has happened a number of times in Bosnia and Croatia on my watch? This placed incredible pressure on commanders in the field who had to make regular technical and ethical judgments on how to respond to the actions of the enemy. In some cases, they felt it was necessary for government to approve the strategy. After the massacre of Bosnian Serb men in Srebrenica, there were calls for NATO to intervene using air power on Serbian targets. This was the first NATO, this would be a first for NATO because it had always been a defensive organization to counter Soviet aggression. Canada was the last nation to give consent to bombing because we faced an ethical dilemma of agreeing to an expansion of NATO's mandate without discussion in Parliament and public debate within the country. Events moved too quickly. It proved out to be the right decision as it forced the combatants to the table, and the subsequent Dayton Peace Accords was a turning point leading to a de-escalation and ultimately an uneasy peace. The second example, of course, where there were a myriad of ethical issues was the deployment by the previous Conservative government of the Canadian Airborne Regiment in support of the United Nations peacekeeping mission in Somalia. Despite many accomplishments in that mission in helping to keep the peace, they were overshadowed by other events, the most notable being crimes committed against Somali citizens. Charges were laid against Canadian soldiers, and a promised public inquiry was about to begin when very unseemly videos depicting racism and disgusting hazing rituals from another unit of the airborne became public. And so the government faced an ethical dilemma. While the military leadership wanted to take remedial action with the regiment, the government felt the cultural problems within the regiment were systemic and beyond repair. That was a value judgment that we made. And so we disbanded the regiment. And as Prime Minister Chrétien said at the time, for the morale of the rest of the troops and the prestige of Canada, we had no choice but to act. So we disbanded the regiment, but it was a tough measure, and it was very difficult for many in the armed forces to accept, because they had taken pride in their service within this particular regiment. Another example was the 1985 so-called Turbot War, which was a dispute with Spain arising from violation of international law governing the rights to fish for turbot in the North Atlantic. With the livelihood of hundreds of Newfoundland fishermen at stake, the government had an ethical dilemma, as did my colleague Brian Tobin, who was from that province and was the Minister of Fisheries and Oceans. Canada could enforce the law within the 200-mile economic zone, but to do this in international waters would be an act of war, which would involve the Canadian Navy becoming engaged in armed conflict on the high seas. The government was ethically bound to support our fishermen, and once Spain understood our resolve to protect Canada's interests by using the Navy outside of the 200-mile economic zone to uphold international law, thankfully the situation de-escalated, and it was very difficult because Spain, of course, is an ally and a fellow member of NATO. In 1996, another example was that there was a lot of pressure from colleagues for the abolition of anti-personnel landmines. Military doctrine at the time was that the use of landmines was an important element for the Canadian forces and consistent with very strong existing international standards. Yet the government recognized that the military recognized the ethical dilemma the government had to confront when thousands of innocent civilians were maimed or killed. And this really was an unacceptable tool of modern warfare. So we decided to adopt a total ban on anti-personnel landmines, including production, export, and the use, as well as destroying its stockpile. And my colleague, Lloyd Axworthy, who should need no introduction, built on Canada's decision to support this support in Canada and of many other countries, and it led to the Convention on the Prohibition and Use of Stockpiling and Production and Transfer of Anti-Personnel Mines and their destruction, also known as the Ottawa Treaty. It was signed in Ottawa, and I was very proud to be there when Lloyd and colleagues from many countries signed that declaration. The last example I'll give, Tom, is one I was in as Minister of Transport, and having gone through the events of 9/11, which I won't get into, but also had an application of international law. But I was a member of cabinet where we had to decide whether to join the coalition of the willing requested by the United States to remove Saddam Hussein in Iraq because of allegations that Iraq was developing weapons of mass destruction. Our security agencies disputed that there was any such evidence of this assertion, and they had information that the Americans had and the British had and the other members of our Five Eyes Alliance had, but our people felt that the proof was not there. Also, the United Nations refused to sanction the American action, unlike I believe it did in the 1991 Gulf War against Iraq. So our ethical dilemma was to choose between supporting the entreaties of our closest allies, the United States and Great Britain, despite the lack of corroborating evidence, and the overwhelming view, on the other hand, of Canadians and others around the globe that war against Iraq was unethical and unjustified. Of course, we chose not to participate, putting Canada on the right side of morality and the right side of history. And I do know that Prime Minister Chrétien, former Prime Minister Chrétien, feels that that was a seminal achievement and decision for the public good, an ethical one made during his time in office. Thanks.
Well, thank you, David. That's a refutation of Machiavelli, where ethics obviously did play a role in a series of decisions that you made or were directly part of. Tina, if we could turn to you now. David has talked about the application of ethical principles, and Lorraine has talked about the development of international law. And you're an expert in one of the most important developments, which has been the concept of the responsibility to protect, which really puts a human dimension above traditional notions of state sovereignty. So can you speak to us about that, please, on that important development which has occurred in the last 15 years?
Thank you very much, Tom, and good afternoon, everyone. It's a great privilege for me to speak to you today, along with such distinguished colleagues, and it's also a very timely discussion as we reflect upon the 15th anniversary of the adoption of R2p principle in 2005. Matt, if I could ask you to put the slides up. Great. Next slide. So in the next 7 minutes, I'd like to take you on a journey to explore the development of responsibility to protect principle by giving you a little bit of a historical context and then examining what happened at the 2005 World Summit, as well as the significance of R2p in international law, and end on where we are today and how we can move forward. Next slide. So the responsibility to protect, commonly known as R2p, is a humanitarian principle coined in 2001 and later adopted by 150 countries at the 2005 World Summit. Essentially, it states that when sovereign states are unable or unwilling to fulfill their responsibility to protect their own populations from genocide and other mass atrocities, the international community has the responsibility to do so. Next slide. The previous one. Thank you. Historical context of R2p begins from the post-Cold War era when we saw the outbreak of new conflict in the 1990s and humanitarian intervention became the new buzzword. There were controversies when intervention took place, as in Somalia, Bosnia, and Kosovo, and when it failed to take place in Rwanda. Next slide. And then responding to the then UN Secretary General Kofi Annan's call to build a new global consensus for protecting people in peril, the Canadian government took a leading role in the establishment of an international commission, which then gave birth to this report on the responsibility to protect. Next slide, please. And in 2005, at the World Summit, R2p was formally adopted by 150 heads of state and government, and R2p was narrowed down to 4 very specific crimes, namely genocide, war crimes, crimes against humanity, and ethnic cleansing. Next slide. And it's very important to realize the significance of these R2p paragraphs at the 2005 World Summit Outcome document. We know, for instance, that the widespread consensus that was achieved, 150 heads of state and government, was very significant. But also, by focusing on 4 very specific crimes, it became absolutely clear that we were interested in both the prevention side and accepting responsibility for populations. The language used here is populations and not citizens, and that's very important on its own. And the responsibility also lies at multiple levels, at national, regional, and international levels. Next slide, please. We should also recognize the Canadian leadership in adopting this R2p resolution, and namely some of the Canadian political leaders who were involved with this, such as Alan Rock, Bill Graham, Mike Ignatieff, and Paul Martin, who really used their diplomatic skills to convince other states that this was an idea whose time had arrived and that other countries should support this despite concerns about state sovereignty. Next slide, please. And it's important for us to also recognize that R2p has very strong roots in international legal regime, such as international human rights law, international humanitarian law, international criminal law, as well as various conventions on the prevention and punishment of genocide, on refugees and IDPs, as well as war crimes and crimes against humanity. Next slide, Beth. R2p marks a very important normative and conceptual shift from a Westphalian notion of absolute sovereignty to sovereignty as a responsibility. So the debate is no longer about what is right or wrong from ethical perspective, but preventing and responding to the worst human crimes in international relations with a very clear framework. Next slide. So today, as we reflect upon R2p's life cycle, we're in this very unique position of internalizing and implementing R2p rather than debating the relevance and usefulness of R2p as a new norm. Next slide, please. And since 2009, UN Secretary General Ban Ki-moon, as well as his successors, have been very involved in promoting R2p at the UN level. And in particular, Ban issued a report on implementing R2p, which had 3-pillar approach. Next slide, please. And these pillars are supposed to be applied concurrently rather than in sequence. And pillar 1 refers to the state's responsibility, pillar 2 on assisting states, and pillar 3, international communities' responsibility to use various tools as needed. Next slide, please. After the Libyan intervention, which was rather controversial, a Brazilian concept of responsibility while protecting also came to the force, and it essentially says we must exhaust all peaceful means before we can consider the use of force. And this is largely due to the global South's concern that force could be used to intervene in state matters. Next slide, please. And since 2009, the UN General Assembly on R2p has considered R2p every year. There is a Secretary General's report, and every nation state has a say on what they've been doing on the R2p front. Next slide. And the IPU, Interparliamentary Union Assembly, has also issued a resolution focusing on the role of parliamentarians in promoting R2p at home in their national context. Next slide. So where we are today is a very interesting question. We have seen some successes in countries like Kenya and others where R2p successfully mitigated the risks of R2p crimes. And over 50 countries have appointed national focal points on R2p to build institutional capacity and improve coordination mechanisms. Next slide. For instance, in Kenya, we've seen that a diplomatic mission led by Kofi Annan, which successfully mobilized the private sector, led to the mitigation of a pre-election crisis. Next slide. But the intervention in Libya became hugely controversial because of the regime change, which then led some countries to see R2p as a tool by Western countries to selectively intervene, which then really damaged the R2p's reputation on the global stage. Next slide. And we continue to see a lot of problems in countries like Syria, where over 500,000 people have been killed and over 11 million people displaced. Next slide. As well as the Rohingya crisis and the issue of Muslim minority in China. Next slide. So where that leaves us is mobilizing early action and prevention remains a key challenge for the implementation of R2p, and often our geopolitical interests tend to overshadow the long-term protection goals and our humanitarian concerns. And Matt, if you could just moving forward, slide, please. Thank you. So as we look ahead to the future of R2p, it's very important for us to consider the role of the veto power for the UN Security Council when it comes to humanitarian cases and R2p crimes, as well as the danger of unintended consequences when we do get involved in another country's human rights issues. And lastly, it's very important for a norm like R2p to have national champions. And here, I would argue that it's very important for a country like Canada, which has given birth to the R2p principle, to regain the political momentum and emerge as a champion in tackling various challenges. Because today, we're not just dealing with traditional conflicts, but also threats from the cyber domain and hybrid warfare, as well as the challenges that these countries are facing from the COVID-19 pandemic. So I'll leave it at that, and I look forward to your questions. Thank you.
Good. Well, thank you. Just before we take questions from the audience, I think Tina's presentation about implementing the responsibility to protect brings an issue that that each of you have talked about and reflected upon, which is there may be international charters or declarations or even laws. But David mentioned the United States under one administration where did not apply those ethical principles to themselves. Many argue China today is doing exactly the same thing in the South China Sea, though the Permanent Court ruled in favor of the Philippines. What do states do which want to be ethical in their foreign policies when they face states that are not, particularly when they're superpowers? let's start with David, and then we'll just go around each of our panelists, and then we'll throw it open to the audience. David.
Well, not to sound too high-minded, Tom, but certainly my time in government, I know that what drove Canadian foreign policy was the desire to do the right thing, to be a good global citizen. We went back to, we fought in 2 world wars in Korea, but in the 1950s under Mr. Pearson, we developed a very laudable reputation in peacekeeping, and we believe very much in the rule of law. But frankly, when you get into tough situations where the other side is disregarding international law, and you then have to take a decision as to whether you're going to perhaps harm your own interests or physically harm the citizens of your own country, or in effect bend the rules and do things that you wouldn't normally want to do. So you've got to be flexible, and that maybe comes back to the quote that you mentioned from Machiavelli. There has to be some flexibility. You cannot be too high-minded to put your own country and your own country's citizens at risk.
Lorraine, obviously when we're talking about the application of potential spillover of international law concepts domestically, in Canada, we do have a Supreme Court, and we have an enforcing ability, which is very different from international law. What do you think about the problems involved in enforcing the international norms that you talked about? Why does it seem to be so difficult?
Well, in the constitutional context, we've actually experienced a revolution. It's a slow motion revolution, but we've left behind in the adoption of the Charter these ideas of state sovereignty internally in regard to these very central core normative conceptions of the individual person who has inherent and equal human dignity with all other persons. It's a challenge to operationalize those concepts domestically, and of course it's very difficult to operationalize them internationally when states feel it is to their advantage or necessary for their survival to commit atrocities. The Supreme Court attempted before the Charter, or I should say some judges at the Supreme Court attempted before the Charter to internalize these normative concepts within other parts of our constitutional system and within our general modes of statutory interpretation and development of the common law, the judge-made law. Those initiatives all were infused with international law concepts. They ultimately failed. That produced a situation where the only mode of legal change had to be constitutional. And we know, if we've read the history of how difficult it was to get the Charter passed. And of course, there were many parts of the Charter that Prime Minister Trudeau had proposed that were left by the wayside because there was no possibility of success and convincing the provinces to agree to those components. And also there were compromises in the actual extension of rights in the Charter, and also in the adoption of the legislative override by which the federal parliament or provincial legislatures can, for a limited period, prospectively negate the operation of some charter rights. And so we live in the world of the possible. And it seems to me that by regarding our Constitution as a living instrument and living in the sense that it is constantly improving its adherence to these normative concepts, and given that the court has opened its doors by making it very easy for disadvantaged people to come to the court, and the court has been very inventive and imaginative and flexible in ensuring that poorly resourced groups are able to put their factual situation before the court, because the court can't apply the charter principles unless the cases are well argued with the factual material. The court has been open to have interveners come forward who are not parties to the litigation, but who come forward with certain kinds of expertise or certain kinds of experiential contributions. And this is why the charter has flourished in its transformational aspirations, because the court has been able to get the cases, that it was possible for the cases to be well argued. And I should also say that, because this shocks people in other countries, although it seems to me, as I lived through it, and as even I think back on it, an appropriate step that Canada took after the charter was adopted. The federal government and the province of Ontario, which I both supported the charter, instituted funding for disadvantaged people whose rights had been interfered with to take their cases to court. When I tell my colleagues in other countries that the governments did this, they just throw their hands in despair and say, "Well, Canada is a golden nation, and what are we supposed to do? How can we compete with this?" So the
Alas,
sorry.
No, go quickly on so I can move on to Tina.
Okay, so I just want to say that there's any transformational and project in the real world is going to be difficult. We need a lot of education. We need better education of lawyers. We need funding so that people who are financially disadvantaged can get their cases into the courts. We need support for these wonderful public interest groups who litigate and support the people whose charter rights have been interfered with as their cases go through the courts, because it's a very heavy burden for the individuals who are the named parties in the case. So I think it's a tremendously complex set of commitments that have to be made, and some of them do cost. But the benefits in having Canadian citizens and residents understand that their rights are protected and the institutions function to consider their rights when laws are formed and applied, and then that one can go to court is the best context in which these normative concepts can thrive.
Good, thank you. Tina, in your slides or in your presentation, you talked about R2p being applied successfully through personal diplomacy in Kenya. You also mentioned Syria, which many people put as one of the great failures of moral or ethical foreign policy in recent years. What do you think is the difference in those two cases? The fact that Russia was engaged in Syria, the Saudis, where that is big battalions, were involved in the Syrian issue where they were not in Kenya, as Stalin once said, how many battalions has the Pope?
Thank you, Tom. That's an excellent question, and a question which we struggle with on a day-to-day basis, actually, in the community, because you wonder why is it that we see some effective interventions in some parts of the world, like the Kenyan intervention, and we continue to see failures in Syria and elsewhere. And it comes down to three issues, in my opinion. One is the issue of political will, and second is being decisive and timely in our action, and third, the coordination capacity. So the case of Kenya was very unique in that It was preventative in nature, and it successfully utilized Kofi Annan's networks in the private sector. So in the Kenyan case, we see that early intervention and prevention is much more successful than intervening in the aftermath. And we also learned from that experience that states alone cannot tackle all the challenges, and we must successfully partner with the industry and civil society. In the case of Syria, as you mentioned, Tom, it is one of the greatest failures of humanity that we've seen in recent times. And we continue to witness all sorts of crimes being committed against the civilian population in Syria. And it comes down to the lack of political will. And the lack of political will in the part of Western world comes from the fact that we've seen the failure in Libya, where the intervention or the application of R2p quickly led to regime change. And there's a lot of confusion and lack of consensus among the members of the Security Council at the UN level. And frankly, with the Syrian case, I think we have missed the timing, and the public, in a way, has forgotten about the conflict as we deal with other news that come to our attention on a day-to-day basis. And when it comes to successful coordination of action in humanitarian cases like Syria, despite the gravity of the situation, we don't really have a very clear mechanism for intervention. So yes, we agree something should be done, and we also agree that something should have been done in the Rwandan genocide. And in the case of the Rwandan genocide, it was really a matter of shutting down radio networks, which we didn't do. And same for Syria, there were windows of opportunity earlier on in the conflict where we could have stopped things and where we could have protected more people. But right now, we're really in a quagmire of some sort where any intervention will cause more chaos and more confusion for the population. And frankly, the UN and the nation states cannot do it on their own. We do need to reach out to the private sector and other actors of civil society and humanitarian communities to really provide the assistance to the civilians and really think of the day after scenario after the intervention if we do go in and intervene more actively.
Very good. We've got some questions. Okay, from Robert Baines. What kind of carrots or sticks are at our disposal to bend China or other regimes to pay more attention to R2p? Okay, David, let's start with you. What are the incentives, or we're obviously in Canada having a huge issue with China right now, who's practicing hostage diplomacy. We don't seem to have many cudgels that we can bring to the battle against superpower. But what are the instruments that can be used? We'll start with you.
I think there's only one instrument in confronting the Chinese on a lot of their unacceptable behavior in the global context, and that is by developing alliances to speak out where transgressions occur. And I think this is going to be the approach of the Biden administration. What we've seen under Donald Trump is 4 years of where alliances have been deliberately dismantled and not really adhered to. We saw that in NATO, we saw that with the WHO, with the WTO. And, any adversary, if they see the opponents are divided, that only gives them license to continue unacceptable actions. And so I think that by enjoining other countries and following the bravery that was mentioned in today's newspapers about Australia's position, in tackling Chinese transgression. I think that by an alliance coming together, that will really move the Chinese leadership to think twice before they continue.
Okay. Other comments on this point about instruments that can be used. Tina, you just answered in my question about kind of instruments that worked in Kenya and didn't work in Syria, and Lorraine has talked about the instruments of international declarations. Both of you have some quick thoughts on instrumentalities to achieve the values that we've talked about?
Thank you, Tom. It's very important to recognize that R2P is more than just a military intervention. And when it comes to countries like China, which is very powerful both economically and politically, the issue becomes even more sensitive and more difficult because Chinese foreign policy and the way China sees the rest of the world is very different than how we see China in the Western world. And they're very sensitive to any infringement on state sovereignty. So the first thing to underline when it comes to dealing with China is that we are probably talking about different things, even if we are focusing on the same issue. And when it comes to China's violation of R2P, for instance, with the Muslim minorities in China, it's an absolutely sensitive topic, and the traditional methods of political condemnation just wouldn't work in the Chinese context because from their perspective, saving face is very important, and having their own say in their own domestic affairs is absolutely critical for the Chinese politicians and diplomats. So in that case, we have to utilize other tools that are available, whether that is, using civil society to have dialogues or offering some assistance or partnering with China's allies like Russia as needed, and really coming up with a coherent strategy beyond just an ad hoc approach that we've seen so far with many of the R2P cases is absolutely crucial. And we also know that Chinese hackers, for instance, collaborate very carefully with Russians and the North Koreans, which then fuels the activities that go towards committing mass atrocity crimes. So understanding the root causes of these issues at hand, beyond what is very visible to us from the outside world, I think is absolutely critical moving forward.
Lorraine, I'm sorry, is there another viewer questions? Okay. Cash, institutions that enforce the rule of law seem to apply strong standards in poor states, but no standards in the rich. Okay, so that's a bit of the similar question around differing standards applied to powerful countries as opposed to poor ones. Lorraine, let's start with you. What does the world community, or what does Canada do about the different applications according to power? Or can we do anything? Does it have to be, as Machiavelli said, the art of the possible?
I think that it's very important in regard to poor nations, new nations, fragile nations, that Canada continue to put resources into developing the type of political institutions that foster healthy democracy, and that build respect for minorities and the disadvantaged. Canada has a strong record in helping emerging democracies, and helping them understand rule of law principles and to strengthen their court systems. I have done a little bit of that work over the years in settings where new constitutions are being developed. Canada has a real contribution to make in the constitution making process in other countries. Of course, this is not; these are not elements that are going to change horrifically destructive dynamics in powerful, rich countries. But it's very important to strengthen the modes of good governance and rule of law principles and adjudicative institutions, so that people can have faith in that their own country is coming consistently into further commitment to these normative standards.
Thank you. Well, I want to thank the members of our panel. We've just really started to touch on a host of critical issues, but the points or some of the takeaways I have from this discussion is that there certainly is a case for the application of ethics to foreign policy. And without beating our breasts too much as Canadians, David certainly gave examples, and Tina did as well, with Canada promoting R2p. And Lorraine, we had a Canadian who drafted the Universal Declaration of Human Rights in 1948. That our country tries to weigh in on that side as much as we can in most of the time. But the panel's also brought up that it's this is where Machiavelli and Thucydides would have their insight is still right. It's a pretty cruel, difficult world, and we still have a long ways to go to try to have those ethical norms be applied to those who are the most powerful. So I want to thank the panel for illuminating those issues, and I want to tell our audience that this is the second in our series on ethics. In January, we will be discussing ethics in and COVID, how a range of personal decisions that we all have to make, which are headline stories almost every day. And in February, we're having a discussion on ethics and the media and social media in particular. Is there a need for a new ethical framework for social media and social media companies? So we never lack for ethical issues in discussing in our world and in Canada. Thank you all very much, and join in for our next series of issues around ethics. And thanks to the panel for very illuminating discussion on a critical topic.